Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 rules Texas judges should follow when ruling on requests for direct access. This one might require a little background explanation first. What is direct access? Well, in the civil litigation system, in the discovery process, the way it usually works is that you request documents from the other party, and that party searches its files and then produces the documents. Generally, you don't get to go over to the opposing party's office and rummage through their file cabinet looking for the documents you want. In the electronic arena, the same general principle applies. And the Texas Supreme Court has laid down some rules that limit when you can get direct access to the other party's electronic devices like computers and smartphones. The complication is that a trial court judge has a lot of discretion in what the judge can order on a temporary restraining order or a temporary injunction. So the rules that would apply to the discovery process technically don't necessarily apply to a TRO or a temporary injunction. And what that means is that people can try to use a TRO or an injunction to get around the limits on direct access. And the rules for that are not that clear. So here's what I think the rules should be. Number 5 is that direct access should almost never be ordered on an ex parte basis. Ex parte means where the party requesting the order is there, but the opposing party or the opposing party's lawyer is not there. You can see how an ex parte direct access order would be very problematic. And I would say that it should almost never happen. It should be really an extreme case where a judge would order direct access to somebody's devices without that person being there to defend themselves. My number 4 rule for direct access is that even if both sides are present at a TRO hearing to argue the issue, the judge should only order direct access if there's some real emergency where something really bad is going to happen before the judge can hold an injunction hearing where the court actually hears testimony and evidence. My number 3 rule for direct access is that generally the court should only order direct access if there has already been some violation of the court rules, or the party that has the device has already refused to obey a court order. Something like that. That's consistent with the general principle from the Texas Supreme Court that usually direct access should not be granted unless there has been some failure to comply with the discovery process. My number 2 rule for direct access is that if the court is going to order direct access, there have to be safeguards to protect the person's private and privileged documents. I've been in situations where the judge ordered direct access without any provision for what to do to protect my client's private information that may have nothing to do with the lawsuit, or even my client's privileged communications with me. That's a problem. And finally, my number 1 rule for direct access as part of a TRO or injunction is that the judge should consider whether some lesser means of protecting the evidence or the confidential information would be adequate. For example, Could the court simply order the person to preserve the evidence? Or maybe the court orders the person to have an expert make a forensic copy of the device. There are all kinds of lesser means that the court should look at first before ordering the relatively extreme remedy of ordering somebody to turn over their computer or phone to the party that's suing them. So those are my 5 rules for direct access. Let me know if you agree or disagree. Please like, subscribe, share, comment, and hey, thanks for watching.